Good afternoon, everybody. Thank you very much for being here. My name is Cecilia Alvarez. I am the Privacy Policy Director for the EMEA region at Meta. And actually, this is the less important thing today because I have the pleasure to have wonderful panelists to address something that I think is very important for us as Europeans, which is the European strategy for data. And I think CPDP has been proud to have diversity in their panels in order to have different angles that are actually presented here. And I think our panel cannot be better represented today. We have probably some of the people here is well known in the privacy community, some others a bit less, because we have, in particular, one panelist who is coming from another world that now needs to be probably closer to us, the antitrust competition one. But let me just give a hint of each and every one, and we'll start the conversation. And of course, if I have forgotten something really important in the CV, please let the audience know, because this will help also to understand all the knowledge that you have been accumulating along the years in the topic that we are actually going to address today. So I will start with Luca Bolognini, Italy, because diversity is also about the countries in which we, all of us, build Europe. An academic and also consultant in privacy for a very long time. I have been reading books and articles of Luca for a very long time, well before it was at Meta, and I continue to have the pleasure actually to continue learning from him. I have also Peter Craddock, Belgium. So he's from this city. He's a lawyer specialized actually not only in data protection, but I would say in digital law, which is probably something that is very true for the others. And he has been also representing actors who have been very active in the ad ecosystem as well, which is something that I think we are going to touch upon as well. With Rob van Heek, so the Netherlands in this case, he has been working for us long time now in the Dutch Data Protection Authority. He has a technical profile in the sense of being closer to what we call an IT maybe person, but he has been also having a lot of experience with respect to the legal landscape in this connection, and he works in the think tank FPF, who is also well known, I think, for this audience. And Patricia Vidal, Spain, in this case, a partner of antitrust and EU law in a Spanish international law firm. She is also the chairwoman of the Spanish Association of Defense of the Competence, which is the antitrust association, and has been regularly actually participating in consultations for European regulations regarding actually antitrust, and specifically also in specific aspects on AI, which is also a topic that we are going to address today. So we cannot but better accompany today for addressing the European data strategy for data, which is aimed at creating a single market for data. And this strategy shows that data is an essential resource for economic growth, for competitiveness, for job creation, for societal progress, for job creation. And it points out in the different kind of regulations also that we have been able to create at the legislator level that the availability of data is actually something that is a prerequisite for the development of our data strategy. And one of these laws that I may cite is AI, but not the only one at all. We have probably a cross-cutting nature of what data entails with respect to the different aspects of how we build Europe as, hopefully, I don't know whether we will be getting to be a champion, but it is good to have this aspiration, and we should be fighting for it, because we have probably all of the elements. Sometimes difficult to reconcile, but we have these elements, and probably we need to have also the brain prepare to work towards this exercise. In this panel, we are going to assess the extent to which current data protection debates are actually congruent with these European aspirations that are, I think, legitimate one, and how we may actually have a forward-thinking way of incorporating our data protection acumen, which is so important and we are so proud of, in our European data strategy. So let me start with what is this European data strategy? And I will ask Rob maybe to guide us in giving us a bit of a description of what it is about and what is the strategy's aim. And well, I think we should be asking for some help for a slide that I think will help Rob to guide us through this snapshot of what is this European Union strategy about. Thank you.
Well, thank you very much, Cecilia. Yeah, obviously, through these 3 days, we've heard a lot about the different instruments that are in the instrumentarium of the digital data strategy. But it's maybe good to level set because we're going to have a more deeper dive discussion today. So the strategy aims to position Europe as a leader in the data-driven economy, and it's established a framework of data governance. And this comes obviously with an important shift in focus. And much of the shift is driven by the competition rather than privacy. The European data strategy aims to create a single market for data by enhancing the competitiveness and data sovereignty. And for example, we'll see this through data spaces like the health data space, finance data space, but also the mobility data space. But we also see it in some other aspects. For instance, in the Digital Markets Act, where search under Article 6, sub 11, is required to also share data out. And obviously there is an opt-in if it concerns personal data. But there's also a requirement to share rather personal aspects of our lives. And that requirement in 611 is that it needs to be anonymous. And here you see a really great example of the tension between competition and privacy, which we can zoom in maybe later on as well. So let us look at...
May I ask you just to...
Like
yes,
this.
because
Okay.
otherwise it's probably more difficult to hear you
So
well.
the Data Act is ensuring the fairness aspect and accessibility of the digital environment. But we also see the Open Data Directive, promoting the reuse of public sector information. The Data Governance Act, to foster cross-sector and cross-border data sharing. Obviously, this strategy is then underpinned by the GDPR for data protection. And then we have the Digital Services Act, Digital Markets Act, for safer and fairer digital spaces. And to zoom in a little bit more, the objective of the DSA is to create a safer digital space by regulating the online platforms and services with key provisions like transparency and accountability of the online platforms, and measuring to combat illegal content, enhance user rights and promote trustworthy online environments. And there are clear lines in the sand in terms of prohibitions with regard to behavioral advertising to children, for example, and the use of sensitive categories of data. The objective of the DMA is to ensure fair and open digital markets by addressing the power of large online platforms. And the Cybersecurity Act is there to strengthen the cybersecurity. But to close then, and to zoom in a little bit more, is obviously the AI Act. The AI Act is there to regulate the artificial intelligence technology, the new evolving in the machine learning capabilities, and it's there to ensure ethical and transparent AI deployment. And if you look at the infographic that we launched today, and it's created by my colleague Vasilis Rovilos, it's good maybe to look 1 year ahead. And if we look at like all the way from now to June 2025, I will highlight a couple of things that are coming towards us. Obviously, first and foremost is the publication in the official EU journal and the entry into force of the AI Act, which marks the 24-month countdown of activities towards full effect and enforcement. September, so already after the summer, the member states have to identify their fundamental rights authorities within 3 months after the entry into force. I'll also highlight at the end of the year that provisions on prohibited AI will kick off 6 months after entry into force. And lastly, the AI Office will have to publish codes of practice for general purpose AI within 9 months after entry into force, according to Article 65 sub 9. So there's, if you all the way go to June, that's like the last thing, the member states will have to designate their market surveillance authorities to act as a single point of contact. There's a lot coming up to make sure that the AI Act is going to work. Yeah, I think it's good to keep an eye on the different elements that we need, just to give a little bit of context for the discussion today.
Thank you very much, Rob. It is definitely quite impressive how we are able to put in a single slide well, the snapshot of the different regulations that we have here, and also in particular that you were mentioning, also the AI one, which is at the center also of part of the discussions today. I will turn to you, Patricia, if you don't mind, because of also your expertise in this connection regarding not only the AI aspect, but also the competition one that is driving, as Rob was saying, so much this European data strategy that is behind. So when it comes to AI in particular, we know that data protection is not the only instrument for driving responsible innovation. It is one of them, but there are other things as well that need to be taken into account. And I would like you maybe that you address these considerations and this kind of, I think, an holistic approach that is required to address this and to be probably, hopefully, successful as the strategy is looking for. And in particular, the importance of competition in this respect in order to have responsible innovation. So let me just pause in this first part of the question, and then maybe I will ask you in particular with respect to how data protection regulators and competition authorities could be working together to contribute to actually the main goal of the European data strategy here. Thank you.
Yeah, it works. Thank you, Cecilia, and thank you for the organization for inviting me.
Closer.
Well, indeed, I feel like a weird animal here because I think I'm the only known data protection or privacy expert. So I will give you my views from a competition perspective. In fact, AI is one of the key topics or hot topics nowadays with competition authorities. Let me do some self-promotion because we just issued at my association one paper precisely on generative AI. It's a very snappy short paper, 15 pages only, which summarizes or spots at least many of the problematic issues that can arise from a competition perspective with AI. And data is one of the things that may be problematic if data is not shared and is simply kept, for instance, in just a single hand of the, let's say, the incumbent. So access to data is one essential element that fosters innovation and will contribute to the development of AI. And within the context of what you said, coordination, I think it's interesting to see that competition authorities and other sectorial regulators need to coordinate and need to cooperate. That's essential. Let me just address three things. There are many other things I could say, but I may address first, for instance, this Bundeskartellamt ruling of the ECJ last year. Then we can address, for instance, I'm not going to go through all the regulations that you just mentioned, but we have in the AI and also in the DMA specific features to coordinate precisely these sectorial regulators in order to avoid, running one against each other. And then something that it was casualty, I didn't prepare it, but it was casualty. 2 days ago, we have the high-level group created by the DMA just having a joint statement on AI, and I will address it just to give you an idea how it should work. Starting with the first one, if we look at the Bundeskartellamt of last year, the court acknowledged that there's no regulatory provision coordinating, for instance, data protection agencies and competition authorities. It doesn't exist, but it doesn't mean that they can run one against the other. They cannot say contradictory things. And it establishes a general principle of faithful and truthful cooperation under Article 4.3 of the treaty. And this cooperation, in the case of competition authorities, if, for instance, they consider that a breach of privacy law might lead to a breach of competition law, an abuse of dominant position. There was a case in Germany because Germany has a special rule. It doesn't mean that any privacy law infringement is an abuse of dominant position. I could stay here discussing this an hour and a half, but it's a special rule in Germany. It doesn't mean that it applies always everywhere. So if you need to find an infringement of privacy law, in order to build an infringement of antitrust law, the competition authority cannot rule on its own on the privacy law infringement because it has no competence. It has competence to apply competition law, nothing else. So there should be a mechanism, an informal mechanism of consultations. Please tell me if this is an infringement of privacy law. Then I will build my case on antitrust. But I need to know from the corresponding authority if there is an infringement of privacy law. If the authority does not respond on time, then I can take my own decisions. But there is a need of cooperation. And this is precisely what saved the case. Because if at that point in time, the Bundeskartellamt had not made any consultation to the privacy authority, well, probably the case would have been lost. But they did the homework well, and they made the consultations. So this is one case in which we see that there's no regulatory framework of coordination, but a general provision of the treaty and common sense, basically. What has happened now with this digital European legislation? That I think that our European regulator has understood that we need to cooperate. And within the DMA, it has established its Article 40. It has created the high-level group. It's a group comprised by privacy authorities, competition authorities, consumer authorities, etc. All of them in equal foot. I mean, it's not that competition law, goes beyond, or competition authority goes with more importance than privacy, or privacy over competition, or consumer. All of them on equal foot and running in the same direction. And this advisory board, because it's advisory, has one of its main tasks to analyze efficiencies and interactions between different sectorial regulations and avoid contradictions in order precisely to ensure that there is innovation and there is economic growth. I mean, the goal of all this is economy. We need to keep markets fair and open, because if you have competition, then you will have growth, economic growth. So it's not, they're not fundamental rights in one side of competition, of privacy, or consumers. Everything has to be coordinated and seen from a holistic view. If you look at the AI regulation, you have something very similar. It's Article 64 or 65, which creates also a board, an advisory board, which is comprised also by different, member state authorities, and also is the European Data Authority invited, and some other experts. All this goes through the same direction. We need coordination. We need to avoid inconsistent regulations, inconsistent interpretations, and above all, we should avoid to forget this main goal, which is to create an innovative and a competitive industry in Europe. That's the main goal.
Thank you very much, Patricia, because sometimes I think we can see that in certain circles, we believe that data protection is in isolation of the economy, or in isolation with innovation, or sometimes as if at odds. And actually, this should be working together. It has always, I think, been the goal of the GDPR, but it is probably reinforced in the European data strategy and this kind of bodies in which we enable this coordination or cooperation to serve a goal that enables actually to reconcile the way in which we have competitiveness, and we have innovation, and we have our values represented in all of this. And this actually is the main goal, that all of the authorities that are expected, let's say, to collaborate in this effort jointly are, in Spanish we have an expression that you sail in the same direction. Well, probably is something that is what is expected here. So let me turn to Luca, if you don't mind, with respect to how we create this single market of data, and how does this look like with our GDPR now mindset in this connection. Do you see any kind of sticking points or things that could be working better in order to avoid tensions that apparently seem to be seen by some regarding data protection goals and the strengthening of European Union competitiveness?
Yes. Thank you.
Yes, there are sticking points.
There are sticking points. No, I will talk a little bit about principles in this sense, because I see sticking points. I see the risk that the balancing exercise could not be something that easy. It's important that authorities will cooperate, will dialogue, will interact, but I really think that the balancing job is a dirty job, is a very difficult job. When you have to balance fundamental rights, freedoms, interests, essential interests among them, you have to tolerate the limitation of the right you are focusing on in favor of the expansion of other freedoms, other rights, other interests. This is not easy, psychologically, not only juridically. To renounce to something, to accept the limitation of your field of specialization, of focus, is very difficult. And that's why Articles 52 and 54 of the Charter of Fundamental Rights in Europe are so relevant, so important. Because we have to try to find a balance respecting the essence of all the rights and freedoms at stake. But we have also to avoid the abuse of rights and the abuse of freedoms, even if enshrined into the Charter, into the constitutions, into the treaties. And so this is a very difficult exercise that we used to refer to the principle of proportionality. So when we think about sticking points between GDPR and other fundamental rights and freedoms, like the freedom to conduct a business, for instance, we should think about our freedom of expression. We should think about proportionality. In Italy, we have mixed during decades the principle of proportionality at the constitutional level with the principle of reasonableness, which is something which brings us to think about the reality. The Constitutional Court in Italy calls this a form of practical rationality in interpreting the norms, in balancing the different rights and freedoms. So this very difficult exercise of proportionality and practical rationality that brings to the balancing between rights, freedoms, and interests is something that sometimes I see, I witness, is not that perfect as an exercise result in case of GDPR and other laws, other norms. The European data strategy, of course, focuses on data valorization, focuses on the other side of sustainability, of secondary life of data in order to allow innovation, research, and so on and so forth. And it will be a fight, in a certain sense, a real fight between different pressures and different needs in terms of safeguards of rights. And sometimes I have seen, I've read interpretations trying to balance between data protection, personal data protection, and other rights and freedoms that made me skeptical. And probably these are signals of what could happen tomorrow, trying to balance and to apply together and to combine together the data strategy regulations, acts, instruments, and all the personal data protection and privacy disciplines. For instance, I will share 2 or 3 examples very, very fast. I think that sometimes me too, we as experts in privacy and data protection tend to interpret certain principles, considering those principles just and exclusively within the universe of privacy and data protection. For instance, the principle of necessity. Principle of necessity. What is really necessary for a processing in order to reach a specific purpose, an objective? What is necessary? What is enshrined in the object of a contract agreed by the parties? Or just what is naturally necessary for a specific purpose? If we agree in a contract that an obligation and something is necessary according to that contract, is it necessary if we assess it in light of the GDPR? Or in light of the GDPR, is it necessary just because the necessity is something objective and not agreeable, not enshrinable in a contract? It refers to nature, necessity as nature. Another example is data monetization. I see that the risk is to interpret in a, let me say, a fundamentalist way the personal data protection, considering data monetization always a form of data protection rights monetization. That is not. Simply, it is not. In many scenarios of data valorization, data monetization, the subject is not monetizing the right, but just the licensing, the use of data for certain purposes and keeping all the rights exercisable. And finally, I would add a point concerning the legitimate interest. I think that sometimes we could recognize more weight to the legitimate interest as a legal basis, and sometimes we tend to exclude the legitimate interest, probably in a too strict way, according to my opinion. I know that I'm positioning myself today. And so also concerning the legitimate interest, I think that we will have to discuss, particularly looking at the European data strategy. And I hope that codes of conduct, for instance, according to the GDPR, will help trying to combine together certain specific freedoms and rights in specific sectors in order to better understand which legitimate interests we will leverage on in certain scenarios. Few cents of thinking. But.
Well, thank you very much, Luca. I think that probably because you are speaking the data protection language, it speaks probably a lot to this audience with respect to the principle of necessity and how this is construed also in accordance with contract law, which sometimes seems to be missed, or the data minimization as a kind of mantra with respect to something that seems to be going into a direction that some do not feel comfortable, and maybe it's a personal belief with respect to what can be done with respect to a fundamental right, instead of thinking also of the resource that it represents, and other kind of examples that we have in other fundamental rights, and the legitimate interest, as you mentioned, which is an exercise also of balance in itself, which seems to be also something that we are not necessarily that used to conduct as a general rule, and is probably one of the legal bases that is most difficult actually to assess because of this very difficult exercise that you were mentioning. I know that this is a topic also in which Peter has been, definitely I have been reading things, so I think that you feel comfortable probably to express also the kind of thinking that you have in this respect, and maybe we can also link this to your experience that you have in the ad regulatory framework, in which this kind of discussions are also present.
Yeah, it's true. It's basically a very topical thing across a lot of industries. And so when we think about how these rights basically should be brought together, because ultimately the exercise of every organization, whether they're a company or a public authority, should obviously be to comply with the law. But there are lots of sources of law that you have to comply with. And so we've heard notably recently about the different frameworks we have to take into account. We have the strong impetus also from a competition law perspective. And then obviously we have different fundamental rights that all come into play. And so you were mentioning, Luca, very rightly also freedom of expression and so on. And so whatever industry I'm active in, I need to take into account the fact that I have all of these rules that I have to take into account that are going to affect the way that I operate, that are going to affect my business, the way that I structure my business. And so a lot of these aspects regarding necessity is being interpreted in very different ways based on what context you're talking about. And so, for instance, if you think about contract law more generally, let's take a broader view to contract law. Well, if I enter into a contract with you and we agree on a certain provision of services and so on, there are rules in place from the perspective of consumer protection notably, but also more general concerns regarding abuse of rights that basically mean that certain kinds of contractual provisions are deemed to be unlawful. And so for outside of those cases, basically we have a bargain, we have an agreement that basically is going to affect the way that we work together. And so everything that's happening within that framework is, generally speaking, necessary in order to perform the contract. There's a general agreement about what this necessity means, and that is not the kind of standard that we're now seeing in data protection. And so if we then move on to the data protection sphere, and that balancing of the freedom to conduct a business, and obviously the rights to the protection of personal data, the right to privacy, the other rights like the right to freedom of expression, the balancing there seems to be a lot more delicate, because we're not dealing with frameworks that have been tried and tested before the courts for centuries. We're dealing with now a way of dealing with concepts that are actually very vague. If you think about the principles of data protection, they are very vague, intentionally so. So there's flexibility, so that regulators can try to say, well, you know, this is the limit, this is acceptable. And that organizations are able to say, well, we have a justification for this. And that's what we're seeing now in the ad tech space, notably, because there, as you were mentioning, Cecilia, I've been fairly active in that space, where there is an idea that basically the ad tech space is too complex, that it is too complex and people are unable to understand the things that are happening. That's basically that necessity component is no longer present because the system itself has become too complex. And I like to challenge that, because that necessity that we're talking about is not actually the necessity that is taken into account when assessing data protection compliance. Think about the idea of informed consent, for instance. We have had some workshops about this over the past few days, where the question was raised, like, what is informed consent when we think about the online ad tech environment? Do I have to know every detail about every step of the way that the ad tech ecosystem is working? No. In no single industry, in no single field of law are you ever expected to be informed about everything. The necessity and the level of information that you are provided, whether we're talking about contract law, whether we're talking about medical procedures, everything is more abstract, because you don't need to know everything. And so there was a comment by one of the panelists in one of the workshops saying, you have the right not to know, and it's very relevant. That necessity aspect, when we link it to the level of information that's being provided, is actually much more vague than you might think. It is at a much higher level of abstraction. And so you have to bear that in mind when you think about that assessment of information, notably for consent. If you go down, look at necessity from the perspective of legitimate interest, there we've had lots of discussions about this that basically are saying, well, you know, you cannot justify something based on this, the necessity link is too weak. But a lot of the cases that I've been seeing, and I do a lot of litigation, we don't really go into the details about that because, well, some of these discussions are too technical. They're too business related. And so then my question often to regulators is that something that you as regulators, as data protection regulators, are best placed to look at? Perhaps it's something that requires more hand-in-hand cooperation with competition authorities, with basically the authorities that are in charge of markets, that are in charge of business models. And so I think, you know, this necessity discussion and that balancing of the interests and also these fundamental rights is critical, because if you go too fast, if you emphasize the right to the protection of personal data, the right to the protection of personal data too much, then basically you risk annihilating all of the effort that has gone into other pieces of legislation that all aim at creating a balance. We're not talking about one extreme. We're trying to allow businesses, freedoms of individuals, of organizations. We're trying to allow everything to coexist in a way that basically is respectful. And so ultimately, that is what it comes down to, I think. So necessity perhaps shouldn't be as fundamentalist as you think.
Thank you, Peter. I think that probably for those who have been working in the data protection space, some of these considerations could be feeling very familiar to you, in particular with respect to the scope of interpretation of what a contract would mean in terms of this necessity. I started my career in privacy, well, some time now ago, and I have been dealing very much with contracts my whole life as well. And one of the, at least in continental law, that you learn is that the obligations needs to be construed in according to the bona fide principle. So that it's not only what the letter of the contract says, it's what the bona fide also interpretation enables you to expect from your counterpart regarding the kind of obligations, either the ones that you are expecting to receive or those that you are actually committing as well. And sometimes this element seems, from my point of view, absent, at least in my experience in this respect, and this also level of information regarding the consent. I've been working extensively in the health sector myself, well before, and the consent that you get from a health viewpoint for clinical trials and others is definitely another threshold that is not in data protection, and I find it somehow sometimes that it's very difficult for me to understand that we have like a kind of GDPR consent that seems to be so unattainable vis-a-vis other kind of consent in matters that are particularly relevant, and I will not necessarily put at the same level everything, but I think it deserves some thoughts. Let me move, because we need to continue progressing, and let me turn again to Patricia. I would like to get also your views on the focus on the alleged market dominance as something that is also, I think, part of the discussions that we are having right now in a kind of intersection that is seen between data protection and, in this case, antitrust law. And since probably you are the one who knows better, definitely in this community that we are, the data protection community, we would love to know a bit more about what competition law says about this.
Yeah. Thank you, Cecilia. Well, definitely, as I
Close.
said, I'm not an expert in privacy law, but I've read many things that from a competition perspective, they shock me sometimes, because maybe it's a question of terminology, simply like that we use the same wording with very different meanings. For instance, essential facilities for antitrust lawyers is something different, and I've seen it written many times. This is essential, and I say, well, maybe it's not essential from a competition law perspective, but that's why I'm here. I need to be paid for something to be something different, and that's why I'm going to try to put into context some concepts I've seen in data protection resolutions viewed from a competition law perspective, and it started with the first issue, what is dominance? And here, maybe some people can think, well, when you're a gatekeeper, and I'm thinking about regulations that we saw before, if you're a gatekeeper, you are dominant. Well, that's not true. That's not true. The DMA, what it did was a shortcut. And it's the aim of that regulation, to avoid having to define and determine whether a company has dominant position or has abuse of its dominant position, which would be prohibited by Article 102. It was so difficult, so hard, the test is so high that competition authorities always arrive late. So they decided to issue the DMA precisely to prevent possible harm in the future, but without the burden to prove and demonstrate that any of the gatekeepers were dominant. Some of them have been declared dominant by the EU courts, for instance, Google, and we have, I don't know how many decisions, and the EU courts confirming that Google is dominant. But for the rest of the gatekeepers, it's not always the case. So what is dominance? Dominance is a technical term created by EU law. And this is a concept that, well, we have many case law, I don't know. United Brands is one of the classic ones, but it makes reference to a situation of market power in which a company can act with independence of buyers, clients, and suppliers. It's so powerful, basically, that it can do whatever it wants because its position will not be contestable. It has nothing to do with being big, with having a lot of clients. It might be that you need a deep economic analysis. In fact, the European Commission has issued deep guidance on how to analyze a dominant position. And you have to analyze buyer power, contestability, actual and potential competition, evolution of market shares, many things that are completely alien to a DMA, to a gatekeeper. In fact, the only authorities that can declare that a company is dominant are the competition authorities. National competition authorities, EU Commission, and, by the way, commercial courts, because now they can also apply 101 and 102 of the treaty, but any other authority can say a company is dominant from a competition law perspective. So that's one thing that I think is relevant, because I've seen many times when you talk to the gatekeepers as dominant, maybe some of them are dominant, but I tell you that there have not been tests run so far by Digicom saying this, you are dominant, or by a competition authority at a EU level, okay? So that's one point. Then another aspect I think is relevant, because I've read a lot about it, is cases of abuses of dominance regarding data, okay? One might think, for instance, of exclusion of competitors, because I have data that is essential for a competitor. Well, in that case, we might talk about essential facilities, which is something I've heard. Essential facilities is a concept, again, an EU law concept, which refers to an item, to an input that is essential for a business perspective. It's not something related to users, to customers, nothing like that. It's like if I'm talking about, I don't know, a telecoms operator that owns the whole infrastructure, I want to enter into the telecom, into the telephony sector, I need access to the network. I need access to that essential facility, because otherwise I cannot compete in the market. So the concept of essential facility relates to the ownership or property of an input that is essential and non-replicable in a viable manner and in a short period by a competitor in order to run a business. It has nothing to do with users. And from that perspective, I've also read many things about the subscription model. It doesn't matter which is the subscription model. You are Meta here, but I mean, I don't care if it's Meta, Netflix, or whoever it is. The concept as such. Can be a subscription model abusive per se? No. The answer, at least in my humble position, no. Why not? Well, for many reasons. Because a subscription model in itself, even if the company is dominant, which is not a sin, being dominant is not a sin. It's not prohibited. What is prohibited is the abuse of dominant position. So can be abusive to charge a fee for a service? No way. Not even the super monopoly can be forced to render a service for free. Nowhere. You have United Brands, for instance. As I said, it's one of the classics, which says that a dominant company can charge fees for its own services. Otherwise, that's an expropriation. It's not a public service paid by the state. It's a company that needs to make profit. So even dominant companies are allowed to charge for the services. That's the first point. Then the second one, the subscription model as such. Well, it was allowed, I think, by the Bundeskartellamt decision, or the ruling, sorry, and it was precisely the way I read it, the court did a good job in the sense that it questioned itself. Can a company, a dominant company, obtain free and valid consent for, in that case, for the use of personalized ads? Because it's so big that maybe it's impossible to have free consent. And it established the key elements for having free and valid consent for a dominant company and says, okay, you can have the possibility to refuse consent if you want to, if there's no, let's say, detriment in the company, if there's not a penalty in the company. But when you see the alternative that the court provides, it says, okay, you can refuse consent and in turn pay a fee. So paying a fee cannot be detriment. Paying a fee in itself as a concept, then we might discuss the level, okay? But paying a fee is not in itself something negative. You should be allowed for it, okay? So that's why I'm saying that as a conceptual issue, from a competition law perspective, it is something that cannot be questionable from my perspective. Maybe you can think about the amount of a fee, and then in that case, you will have to go through what we call exploitative abuses. But there is also a long history of case law which explains when a price is abusive for excessive. And this is not something, even if you have a high price, this does not mean that it's excessive and it's prohibited. It depends on many factors, on each circumstances of the case, and if there's no objective justification. It has to be a blatant, excessive price. And I put you an example, and it's something we were involved very recently. When you increase your prior price per 20 with no changes in costs, and you are a monopolist, well, maybe, and it's a cancer drag, maybe you're abusing your dominant position and exploiting that position. There's no justification for such a change, so blatant. But you have to look, for instance, at the economic value of the services or the products. You also have to look at comparable products, and comparable in a broad sense. And you can compare something that is similar. So I don't know, I mean, if you look at subscription models, I don't know, my child, he is paying on his own the subscription for Spotify. I have the free access of Spotify, but he's paying for that. I say, okay, this is for what you're using my payroll. Well, he's expending his payroll in that. So I think there's not a huge difference in what you're paying for Netflix, Spotify, or Meta, or any others. So I think that's a good point of comparison. So just to summarize, from a competition perspective, access to a facility is essential only if you're going to compete, not if you're a user. Secondly, dominance is a technical concept. Third, it's not abusive to ask for payment for a service. It's normal because we are not public authorities. And the last one is that maybe what you can question under competition law is whether a price charged by a dominant company is abusive or not, but it also has its own legal tests. So when I read many things, I'm shocked because they don't match with competition law, at least from my perspective.
Thank you very much, Patricia. I think that you just confirmed that, as always it happens, any field of law, it's a science in itself, so that we cannot be amateurs, antitrust lawyers just because we know about data protection or the other way around. We need really to know our actually field very well in order actually to be addressing the things, at least with legal rigor. Let me address now to Rob and to Luca. Actually, both of you, probably the last question in order actually to leave also the place for questions, and as it is customary here in CPDP. So we have seen, you have mentioned some of you, regulatory decisions on the pay or consent models, and I would like to have your views regarding the implications regarding this European data strategy that has been the common theme of all of your interventions. Who would like to start? Rob, did you want to go first?
Yeah, that's great. I mean, we've heard a lot about necessity and the balancing, and Luca was very elaborate on setting that scene. But I also want to add that the principle of proportionality plays a critical role in determining whether such a paywall is justified and to what extent it aligns with EU laws and values. Well, if we look at the paywall through the lens of proportionality, I think there are several factors that must be considered. And obviously, necessity and legitimacy are two components of that proportionality view. The paywall must serve a legitimate interest, such as providing a service or content that requires an investment to produce and maintain. The use of the paywall should be necessary for the sustainability of the service. But it also, that's the second point, it needs to be balanced against the other rights. The implementation of a paywall should not disproportionately infringe on the rights of individuals, especially concerning their right to access of information and the protection of their personal data. For example, if a service processes personal data as part of the access mechanism, it must comply with GDPR principles, ensuring data minimization, security, but also transparency. So common to transparency and consent, if the service involves the processing of personal data behind the paywall, it must clearly inform users about what data is collected, how it's used, and obtain their consent in compliance with GDPR. Which brings me to the fourth point, it's about accessibility and alternatives. I think this service should consider providing alternative access options for users who cannot afford the paywall, but then especially if the service constitutes a public interest or essential information. And this consideration obviously helps ensure the economic barriers do not unjustly restrict access to information and services. So the key question is whether, for instance, the availability of news is exclusively accessible on a platform only. Or, I mean, if we look at the public organizations that are responsible for, like the news, like the public broadcasting organizations, it's specifically a founding building block of our democracy to make sure that users get access and it's for free as well, that do not have the ability to pay specifically for targeted services. So taking these into account, so next to necessity, I think the proportionality element is also very important to take into account. And that's not just for the social networking platforms, but it's a principle that we could apply also in, for instance, the opt-in and opt-out controls that are added, for instance, in the Digital Markets Act, where there's overlap between an instrument, inter alia the GDPR, when it's about anonymization, when it's about consent. These are like specific building blocks that the legislator has built in the new instruments. Proportionality of these user controls under the privacy rights are important to consider. And I really want to make the case for the last one that I addressed is the provision of the alternatives for users who cannot afford, but that's linked to the availability of information that's required to have access to in a functioning democracy. Luca.
Luca, same question for you, if you don't mind.
Yeah. A few comments on the pay or consent opinion issued by the EDPB. When I read the opinion, I was surprised because of certain concepts, terms that were used in the opinion were, in my opinion, too generic. And I agree with Patricia. Not being a competition lawyer, but I start wondering what is a large online platform. what is this new creator? How the dominant position can be relevant also for the data protection aspects. And also, from my angle, and so just thinking of data protection, new concepts, so not brand new, but quite new concepts like granularity, added to specificity and transparency, or the concept of detriment, interpreted in a very strict or extended, it depends on the perspective, way, so that the payment of a fee is itself a detriment according to the opinion. And other concepts like the network effect and other concepts that you can find it in that opinion. All these elements altogether brought me to think, to wonder, is this kind of general opinion really useful? Is really able to adhere to the reality, to the specific scenarios, can be helpful for the data protection authorities' orientation for their decision on the specific case. I'm not that sure that the general and generic opinion issued by the European Data Protection Board can serve as an helpful instrument. If written in this way, and I would add another comment that I elaborated after the reading and the rereading of the opinion. What kind of instrument is an opinion issued by the EDPB? What kind of instrument is a guideline? We all know what is, and we all know what the GDPR states, but such instruments can have a huge impact just on the balancing exercise I was referring to, I was mentioning earlier. And so they have a normative power, and so I wondered, but why don't we think about, in perspective, the GDPR should be updated and improved? Why don't we think that certain decisions, certain guidelines even, or opinions in this case, another instrument, why don't we think about the option, the condition to carry out an impact assessment before issuing opinions, before issuing guidelines? I mean, we have to carry out impact assessments also at the national level for new legislations, new norms. Probably also an impact assessment, considering also the other disciplines and the side effects of certain orientations, for such instruments could be a good improvement for this kind of decisions and guidelines. And so I wanted to share with you these reflections, more than to talk about the specific points of the opinion or the decisions in the pay or consent field. We will see. But I think these are questions to be addressed, and now it is the right moment to discuss about this, since we are thinking of the new GDPR in the next years after the assessment.
Thank you very much, Luke. I think that you are very right in thinking that the process affects the substance, and therefore to think about how we improve also in the process of this exercise that is difficult, of doing this balance among the fundamental rights, but also having, at the end of the day, also a pragmatic not in the sense that it's easier to do, but to understand the real impact of the decisions that you are taking in, at the end of the day, the purpose that all of the authorities, including the data protection authority, should serve in order that our European data strategy is a reality, is definitely something that probably is a best practice to be maybe assessed. I will maybe, if you want, and there is something that you think that you would like to have said, and my questions were not necessarily addressing something that you believe was relevant, please do so. Otherwise, I will leave the floor for questions. Peter?
I'll be happy to add something, because it was linked to what Rob and Luca were just saying now. When you think about the whole discussion that we have had recently regarding these models and what should be the position of regulators, but also more generally regarding the balancing of fundamental rights, one thing strikes me is that a lot of the time it seems like we're talking past one another. That we have regulators who are not necessarily taking into account these impacts, these business realities, that we have individuals who are believing that their rights are fundamental no matter what, that basically there are no exceptions whatsoever. And then we have businesses who are not necessarily taking into account all of the opinions of the users. And I think we do have to move a bit forward and try to have a bit more understanding of the other perspectives, because my feeling I work a lot for businesses, is that there's this huge impression that basically regulators and users have forgotten that basically in order to be able to benefit from a service, that service has to exist. And if there's no money in making it, if there's no means of funding it, there won't be a service. And so to your point about proportionality, I just want to add, if for instance, the availability of news depends on a platform, I think that in Europe, most news organizations still have their own website. We're still traditionalist from that perspective. So we're not necessarily impacting the availability as much as some might think. And so I think there are lots of things that we have to take into account in these discussions regarding these fundamental concepts. And we should never be blind to the other perspective.
Wow, you have definitely something to say. Let me open the floor to questions. So if you can help me by raising the hand, then I will. Okay, do you want to take the mic? Or?
We'll take that. So you remain with your mic. Oreste Pollicino, I am professor of constitutional law and Fulbright scholar at NYU, and the reason why I would like to add, first of all, congratulations for the conversation, because it was really, really inspiring. I have 2 or 3 comments. I will try to be brief, try to stimulate further conversation. Being 1 year in the United States, I think that it is very important for European Union also to not be seen as a fortress that has not interconnected bridge with the rest of the world. It's a very European-centric conversation, I understand totally, but unfortunately or fortunately, the technology we are speaking is global. So I think that a quick look to what's happening to another part of the world might be a lesson to learn and not only to teach. This is something else about Brussels effect, the attitude to teach and not to learn, but it's another chapter. Coming back to my chapter, what I would like to say is that having been 1 year in the United States, what I've seen is that there is original sin that now has a high price. The original sin is to have seen always First Amendment as the Holy Spirit that basically makes impossible any regulation, for example, now against disinformation. They are incredibly terrified by external interference from China and Russia, but they are simply unable to regulate because they gave, also for cultural reasons, an incredible power to, as Her Majesty, First Amendment. Now, there is also another point. The other point is related to the lack of the federal legislation in privacy that is simply missing. It's a shame for AI regulation. It's missing because there is still this Fourth Amendment written in 1791 that speaks about physical trespass. It doesn't allow to protect privacy as it should. Okay, if we have this model, I think that we can take a lesson. The lesson is to avoid to do the same mistake for our First Amendment, for our European First Amendment, that is clearly data protection and privacy. What do I mean to not do the same mistake? To not give an absolute dimension. This is obvious what I'm saying. The Court of Justice said this since 20 years. There is no right as absolute dimension, but there is like Luca said, a proportionality principle that is called less restricting alternative test, by the way. It's exactly the same test that the European Court of Human Rights is doing when it speaks about necessary in a democratic society, which is the mean that achieves the goal in a less restrictive way for the conflicting rights. It's nothing new under the sun. But unfortunately, or I would say reasonably, for a first period, we had the European Union really, let's say, focusing on this absolutism in data protection. There is a reason. The reason was that the European Union was not a complete, mature constitutional legal order. It had to react to something external, starting with global surveillance, and need to prove that there's some constitutional roots Euro-based. Now, I think it's another season. There are seasons in the constitutional legal orders. The season is the season of the maturity. What does it mean? That we can allow ourselves to have a less radical approach. Meaning that if you look at the European Charter of Fundamental Rights, it's obvious that Article 7 and 8 has the same value of Article 11, but also Article 16 is not a detail, freedom to conduct business. So what I want to say is simply that we have a constellation of rights. It's obvious, but it's not applied in practice at the moment. And this is the second point. Sometimes we see today some trends that goes in this direction. Look at what happens in Luxembourg with the Quadrature du Net. I mean, the fact that they went from Grand Chamber to full courts, it shows exactly that. So yeah, I bring as saying that I have to finish. I see as contrast within the court. There is a part of the court according to which, they want to apply the traditional way, to apply in absolute way for, data protection. There is another part of the court that's saying, look, maybe it's not exactly like 10 years ago. Also like 5 years ago for the first decision Quadrature du Net. We can allow to be more, let's say, reasonable in the balancing. And this is the second point. The third point, and I will end, is which is the take. No, there are very two short points. The first one is, which is the takeaway that I can take from United States experience, is the hybridization. It doesn't mean confusions between authority and between fields. But it means possibilities to cooperate, like our speaker showed, in terms of cooperation between fields. Before there was only Her Majesty Antitrust, then there was data protection, then there is also... Yes, there is other questions, so I close. Thank you very much. And I think that the debate is promising and I was too long.
Thank you, Oreste. I think there are other hands, so let me see with here. You can.
Thank you for this discussion. My question is to Rob. Rob, you mentioned about network effect, proportionality, and balance of interest, and so on. So let's say I'm a user who is using the services or platform for the last 10 to 15 years, and suddenly I get a pop-up that I have to pay or not pay. If I don't, but I don't want to share my data for personalized behavior advertising because I want to save. So in this panel, I see the panelists are more in favor of not pay because you believe that economic growth is also necessary and sustainable business is also important. But what about the user? Who is going to save the user? Who is going to work in favor of user? How can I protect my data, especially for personalized behavior advertising? Thank you.
Sorry that I jumped, not data privacy. Do you need light in your house? Okay, no, yeah, but I'm saying, if you need a service, because you cannot live with it, I don't have any social networks. Not true, I have LinkedIn, because I need it for, but nothing else. And I can live with that, okay? But having said that, if you need light, you need to pay for it, okay? People think that when they use a service for free, it's because they are charity. No way, you're paying with your own data. It's a trade-off. From a competition perspective, this is so clear. And that's why the DMA, and if you go to merger regulations and merger decisions, they're always thinking, okay, you are collecting data, this is an asset. People is paid with their data. That's true. So if you don't pay with data, or if you pay with not personalized ads, which is what brings money to the company, how the company is going to be paid? By the air? Maybe, depending on the degree or whatever, you might ask about, as I said, the price. But asking for a service for free, with no financial income, I mean, maybe that's a public service, and this might be paid by the state, but not by a private company. This is competition law. I don't get into, I mean, users are also behind competition law, consumers. But what you need is a competitive market structure and have competition there. And maybe if you have a good competitor, they can compete on fees, or maybe on not charging. But asking for not charging for a service, I find it very weird. All users pay, sooner or later.
Let me add that the question on who protects the user obviously is disconnected to getting access or signing up to a service. I mean, in terms of user controls and implementation of the principles that are enshrined in Article 5 of the GDPR, like data minimization and purpose limitation, for example, the ability to opt out depending on the basically the legal ground that's required. Those are things that if you enter into access of the service, you're using the service, we have like privacy dashboards, we have like layered approach to limit or restrict or to opt out of certain types of data. The real question on whether it's fair to pay with data in order to get access, it's a complex one. And my view is that the lens that the DPAs have, the mandate that they got from the legislator, is very limited. And we now see that the competition angle is overlapping that space. But obviously, due to the balancing of the fundamental rights and the Treaty of the Functioning of the European Union, it needs to be balanced. The real question on is it fair to tie consent and the question whether that consent is free, specific, informed, etc., all the criteria that stem from the GDPR, whether that can be connected with the paywalls that we see on social media services. But that's a different question than who protects the users. I think that's the question on the controls that are available to the user once you actually subscribe or you log in and you start using the service.
Perhaps just to add on that last point, Rob, I think there's one aspect in this discussion regarding indeed these justifications that basically mean that this notion of consent in that context, it differs. It is not the same consent when basically it is required by law as when it is something that's just one free choice among several legal grounds. And so I think we shouldn't disconnect this either from the practical reality for certain companies, whether it's on the basis of e-privacy rules, whether it's on the basis of the DMA, and so on. There are lots of situations where you are required by law to go down a certain path regarding legal grounds. And so then, in those cases, we shouldn't say, well, we're just talking about consent. We're not talking about consent in the same way as under Article 6 in that list of different legal grounds. And so that's always very important to bear in mind when you think about that context.
Thank you. I think that I understand that we are out of the time thing of the bell, but I understand that there is someone who wanted to pose a question, so please go on.
Yes, thank you very much. I'll try to be brief. I really try not to comment, Peter, but then I always comment when it's impossible not to. especially on your ideas. Rob, thank you very much for bringing the discussion about the balancing and the fairness, fairness bit in the end. And this is where I wanted to go back to, because Peter, you were saying that it's time to be constructive and also understand the different interests, you know, the business and the reality of the situation. And I agree 100%, 100%. But the agreement starts with the basic facts. Right, and what you say, for example, is that, you know, that companies have interest in conducting business and earning money, and you defend that as a legitimate interest. But this is not what the conversation is about. This is not. The conversation is about maximizing profit, whatever means necessary. This is what it is about. And I'll tell you how. 2020, the UK, the Competition Markets Authority, they analyzed the market of, in this case, Meta and Alphabet, and they said the fair shareholder estimation of the return of the invested capital for Meta's case is 10%. They receive, in 2020, 50%. That is unprecedented on the market. And they claim that this is because of the use and abuse of the data. The same finding was done by Spain, France, Germany, and the US. The amount, the percentage that they earn is way, way high compared to what is the fair estimate. One thing. Then, Bundeskartellamt case, when they were going after to see what was going on, what is the legitimate interest that is presented, they identified profit maximization, not earning profit. It's about maximizing profit. It's not about earning profit, because Meta can sell random advertisement, random. They could still be earning profit. It's not about that. Meta could have contextual advertising. It's not about that. It will be less profitable, but it's not about that. It's about advertisement that is based on maximizing the amount of data that they process to maximize the amount of money that they earn. And the balancing of the consumers happens with that interest. And this is the basic fact that we have to start from. And that we have to accept that there are risks on the side of the consumer. 2009, when it was decided, the reform of the GDPR, 3 reasons were given. One of them was rise of social networks. The second was behavioral advertising. These 2 things were in 3 reasons why the GDPR came to be, right? These are go in the memorandums, see that. This is the starting point, because it was considered that the behavioral advertising and the social network together has high societal risks. And Meta Bundeskartellamt case, Meta presented the risk was non-existent. Behavioral advertising was actually beneficial to the fundamental rights of the consumers. This is it. It's basic facts that some parts of the businesses don't want to accept. And unless these facts are accepted, we cannot construct together the fair advertising technology market. Thank you.
If someone wants to react to this.
I'm going to react just by the reference to Spain. I'm not aware of the competition authority saying any price is high. Maybe you're talking about privacy authorities. I don't know if they are allowed to discuss about prices, margins, what is a price, excessive pricing. As I said before, competition authorities are allowed to analyze whether a price is excessive for a dominant company. I don't know if privacy data agencies have this function of saying what is a fair margin or not. Second, from a competition perspective, profit maximization is natural, is normal, and this is not a sin, it's not forbidden. What is forbidden is to abuse by excessive pricing, but excessive pricing, profit maximization is completely different. Third, from a competition perspective, again, competition perspective, a price can be high, you can have margins, but you have to compare it with other factors like value of the services and comparable products. What I'm simply trying to say is that having high margins maybe sometimes is a clear indication of exploitative abuse, excessive pricing, but you need to conduct other analysis, at least on the antitrust law, and you have huge and large list of case law. And as I said, I'm not aware of any competition authority saying that subscription in any of the platforms I know is abusive or excessive. And I said it's not a sin to maximize profits. Maybe from a data protection, it's different because there's another functions for these authorities. But it's something I'm not aware of.
Perhaps also just to add that from the perspective, I know Alex, you'd love to respond to that, I see. But so if we go back to then the data protection side of things, because that is also the angle that you were exploring. Again, it is a question of, is any practice deemed to be lawful or not? It comes down to that. And whether the profit margins are high or not is actually irrelevant from a data protection perspective. What is relevant is whether a practice is deemed to comply with the law. And I hear a lot of comments regarding behavioral advertising. Like some of you know, I prefer profile-based advertising because I think that's more clean and more relevant to the actual things going on. But it is not something that is personalized, except on certain platforms. It is not based on my behavior and predicting what I will do as a human being. It's only in a very specific environment. So we shouldn't basically demonize the idea of profile-based advertising. And the lawmakers have not done so. They only excluded it in very, very specific circumstances. So if we're outside of those circumstances, the rule is, it is so far seen as lawful. And so based on that principle, I think, again, you know, it's a matter of trying to understand one another. Again, I'll get back to that point, because if a business uses that business model, it is because it works for it. Contextual advertising works for some businesses. It doesn't work for everyone. Randomized ads work for certain businesses, not for everyone. And so when the lawmaker itself doesn't declare something unlawful, and that regulators step in to say, well, I think you should be offering an alternative that is based on general ads or contextual ads. And basically, they're making a judgment call based on what actually should be a business decision entirely, what works for me, what doesn't. And the law itself is clear. Nothing is illegal unless it is prohibited. And behavioral advertising is not prohibited in general.
Well, thank you all. Thank you very much for being so late, because it's Friday. Probably you hopefully are going to start a wonderful weekend. Thank you for permitting us to actually contribute to the discussion and for a European data strategy that is hopefully able to be achieved by everyone. Thank you. Bye-bye.